of those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down. You could open that. The 154 timestamp, if you go to the left, please. Do you see that right above the green line?
Yes.
12/23/58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
No.
Sustained. Strike it.
In the final exhibit? Let's go back to the data. You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range? Objection.
So ask it differently, Mr.
Okay. You suggested the reason why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a.
This data from the green, would you agree it indicates the beginning of the three-point turn, and then the orange is at the end when the car is already in motion at 11.2 miles per hour? Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came in and gave an opinion.
I could have.
But you didn't.
I did not.
Do you have any reason to test the accuracy of this data that's been broken down? Objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, a wider range, right? Even though this analysis depends on the end of the three-point turn, wouldn't you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the three-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Green.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct.
And so if Aperture's position is the matching times at the end of the event, by going back to the beginning, isn't that even more forgiving than the engaged scientifically? Objection.
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
Right. The opposite of cherry picking, right?
Sure.
Do you have an opinion to a reasonable degree of forensic data certainty about whether the text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is the text stream data would not reflect the collision, correct?
That's not what I said. I don't have an opinion.
and you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really hear
I don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's
You're-
19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
Okay.
You were asked a number of questions.
Yes.
Thank you. You were asked a number of questions a few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen if I could. Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree
Yes.
and you hold a master's degree.
I do.
You ever lied to anybody about that?
No.
Mr. DeSogra, what is the only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report, the
So-
May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
It was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection to look at a chart?
It would. Thank you. Yeah, there are a lot. I would have to really use my finger to count them all.
Okay. More than 8?
Total after 1162-2,
Only on the 29th.
there aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Safe to say there are many, right?
Yes.
May I approach?
Yes.
And again, this goes back to a question that you were asked by Mr. Brennan. I want to follow up on. In no instance were any of those related to a collision, to your knowledge, correct?
Objection.
Sustained.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of them were triggered by a collision.
Thank you. I want to ask you a hypothetical, if I could, based on questioning by Mr. Brennan surrounding the 12/32/09 lock event. Do you remember him asking you about those questions, about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2 text stream event or trigger event and the lock event at 12/32/09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay. If you were told that there was another interaction phone event on John O'Keefe's phone at 12/32/16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12/32/09 to 12/32/16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them, all 30 of them, would occur at a point in time with, let me rephrase that, all of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Thank you. If you were told, let me give you another hypothetical, if you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12/33/14, would that impact your opinion in any way?
Objection.
Sustained.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess...
Hold on.
Of course.
You need to, we have to turn the fans off.
And I'm not speaking loud enough?
Right.
I'm sorry. I'll raise my voice. I just don't want to scream over people, but I will raise my voice.
Let's try this for a few minutes.
May I start again?
That question, yes.
Thank you. You were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data, or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing, where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key-on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again, so I'm as clear as I can be. When that button is pushed for the on event, the key on event, is that like a stopwatch? Click, a stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
As a clock.
Are those two things independent of one another?
Completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from, is these are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints of Mr. DeSogra's PowerPoint. Can you highlight the table on the left, Mr. Wolk? Thank you. Did you create this table?
No.
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
It was. It was
Did you type-
it was a screenshot.
Thank you, screenshot. Did you type a single word on this?
I did not. I added a green box.
Put a green box around it.
Yes.
You didn't type anything on this, did you?
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming?
Objection.
Sustain.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection.
Sustain.
May I have just a moment, Your Honor?
Sure. Do you need the light on?
I don't. And we can pull that down. What was your entire analysis predicated on? What was it based on? The foundation of it, as you explained your analysis to this jury during the course of the day.
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No.
Did you change any of their analyses?
No.
Did you explain their analyses?
Yes.
Sustained. Ask it differently.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, and your presentation to this jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You were asked whether the genesis of your analysis relies on knowing the source of the calls, correct? You remember being asked that by Mr. Brennan?
Yes.
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
That's correct.
You were also asked why you believed Mr. Burgess did a quote-unquote more detailed report in May versus January of 2025. Do you remember being asked that just a few minutes ago?
Yes.
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting event?
All of them.
Thank you. That's all I have, Your Honor.
All right. Mr. Brennan.
So, Mr. DeSorga, this demonstrates the danger or the difficulty.
Hold on.
This is a speech,
Start,
not a question.
start the
It's
question
cross-examination.
differently.
It is. It has to be a question.
Start. Go ahead, Mr. Brennan.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, put on 10 please, when you're looking at someone's report, you're guessing as to what they thought or presumed. if you haven't spoken to them. Fair?
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides itself or resides on the infotainment system, correct?
There's a transfer of data.
And
Yes.
so unless you actually do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an iPhone or from the infotainment. Fair?
That's right. I don't think that's.
And so when you
No.
don't actually do the work yourself, and you just presume or you guess, you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess. I used the data in the reports and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, and you telling me right now, to a reasonable degree of data certainty, that that information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself rather than just Monday morning quarterbacking somebody's report.
Objection.
So I'm going to strike it, ask it differently,
If
Mr.
you
Brown.
actually did the analysis yourself, you wouldn't have to make a presumption that it would be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the testing.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No,
Did you read Ian Whitten's report?
no,
You don't know if that testing was done, do you?
I don't.
Objection, Your Honor.
I'm going to let that stand.
You don't
Next.
know.
I do not, sir.
And so if you're wrong, your assumptions and product are then wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer, frankly. I'm not sure how to give you a good answer to that
If you
question.
have the wrong data when you're doing your analysis, then the final analysis is going to be wrong if you have using the wrong data. It's that simple.
Yes,
Right? You don't have to be a scientist to figure that out.
yes, that's,
Okay. If we could have Mr. Welcher's 33. If you could open that up, please. You were asked about whether the window is within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I see vehicle speeds, right, in those first couple of lines, yes.
Yes?
Yes, I see
Yes.
vehicle speed.
If you go to the bottom, at the end, the car is still moving, yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving, yes?
At the end of the record, there is a vehicle speed, the car is moving. That would be my assumption.
Okay. And so, when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data, yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window, yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real-life event.
Yeah, absolutely, the end of the recording.
Okay. And so, after that window, 12/32/04 to 12/32/12, you were asked a question about what might have happened 4 seconds later, 12/32/16. Remember you were asked about that?
Yes.
Did you know at 12/32/16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
And between 12/32/12, which is in the 10-second window, and 12/32/16,
Do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
You don't know.
I do not know.
Thank you. May I briefly draw?
Okay?
123216 wasn't just at Mr. O'Keefe's home, it was moving at the steps near it, correct?
I didn't review the phone data, so I don't know.
Did you review anything to indicate that the steps were taken over the course of 83 feet?
Objection.
Anything
So
else?
that's sustained.
You were asked just a second ago, what about the data? What if it's wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
All right, Mr. DeSoger, you are all set, sir. So you can step down. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch if you'd like. All right, jurors, we did that to have me decide whether I'm going to let you go home now or not, and I'm going to let you go home. So that 5 minutes that just took means that you get to go home, because we know we'll be longer, and we don't want to do this to you, okay? So we'll break for the day. I have to give you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Additional caution, please be very careful. Continue to be careful with your social media use. We will see you Monday. Monday will be a full day. And we'll start right around 9 on Monday morning. So we'll see you then. Have a great week.
Please rise to the jury.
Chrissy? We'll come back. I'll come back in 5 minutes for the voir dire.
You are unmuted.
Floor is now open. You may be seated.
So you're going to step up, face the question, raise your right hand.
You solemnly swear the evidence you give the court in the case now and hearing to be the truth, the whole truth, and nothing but the truth, so help you God. Thanks. You can take the stand.
Thank you.
You're welcome.
I know this is a really an opportunity. There is a witness outside. Do you have her ready just to get her?
Sure. Is she right outside the door?
Last time I checked.
Do you mind, sir, if you can stay right there?
Sure.
And it'll just be a few minutes, okay? Ms. Gianetti, when do you need this witness back? Monday? So I'm going to need her at a microphone. Do you have one on council table there?
We do not.
So the podium, or one of those back where Eugenia is. Thank you. No, there's a microphone a little closer. We're just follow the.
Stand up. Thank you so much.
Hi, good afternoon.
Hello.
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day?
Yes.
All right. So we're not going to reach you today, unfortunately, but you were summoned to be here?
Yes.
All right. So that summons is still good until we reach you. So you're going to have to come back Monday morning, okay?
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay. Thank you very much. We'll see you Monday morning. Be here before 9, okay?
Will do.
All right. Thank you very much.
Thank you, Your Honor.
Go ahead, Mr. Alessi. Oh, geez, Yannetti.
That was a big compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
You've also been here all day.
Yes,
Sorry for making you wait.
no problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him, essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this
So
old guy.
can we turn off the fans and the air conditioning? Are they all off? We're just going to do that, sir, so that we can get through this a little bit.
Absolutely, sure.
Much better, thank you. So you say you've known him since middle school, elementary school?
Yes,
Graduate high school with him?
yes,
And are you friends after high school as well?
yes,
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes.
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay?
Okay.
May I approach?
Yes.
Would you like this marked for identification first, Your Honor?
Yes.
Exhibit NNN for identification.
Now I'll give it back to the witness. Thank you.
Thank you.
I think he's all set, Mr. Newman.
Thank you, Rona. Sir, have you reviewed that entire document?
Yes.
Does that look familiar to you?
Yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years. Definitely years.
And that's a portion, in other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
It is.
Do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes.
So as of January of 2022, you would have had a passcode to get into your phone, correct?
Correct.
With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end. And you don't have to read the actual text, sir. I just want to...
Sure. I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay. And what you
So I
type...
have a different copy.
Oh, I'm sorry. It's, for the record, it's on page...
What's the bottom page number? So what are the last 2 digits of that? 4. All right, thank you.
And for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
Sure.
That's not something, I mean, it could have been something that I would say, yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip,
And whom do you know as Chip?
Michael Proctor.
Now, going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
So, yeah. So let's not, if he recognizes, I don't want to put names out.
Oh,
there.
I don't either, Judge. That's why I was saying first names. But if that's sufficient that he recognizes...
Why don't you refer to the last 2 digits in the phone?
Sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
Okay. You see, I'll list the last 2 digits of the phone numbers that don't have a name associated with them. Okay?
Okay.
If I may just have a moment.
Yes.
Yeah, of course, of course. Okay, starting with the phone number that ends in 51. After you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you,
Yeah.
of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 93, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right. Now, I'd also ask you, with regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
And with regard to whether this is a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a moment, Your Honor.
Okay.
Just one more question for you, sir. Does the text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further. Your Honor.
Mr. Brennan?
Thank you. Good morning.
Morning. Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
Nothing on that.
All right, so sir, I'm going to ask you to, you're all set.
Okay.
I'm going to ask you to step down.
Okay, thank you.
Your Honor, given that unfortunately this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right, sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right, thank you.
My name is Thomas Campbell. My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So, sir, you can leave,
Okay, thank you.
all right? And thank you, Mr. Campbell. We'll see you, we'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Thank you.
Sir, watch your step coming down.
All right. We'll hear you, Mr. Yannetti.
So, Your Honor, my understanding is there's an objection, so I'd rather respond to the
No,
objection.
I want to hear you as to why this is admissible.
That's fine, Your Honor. I'm going to just have a moment. So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay, all right. So regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it. And nobody discussed any of the emails with him. But the SJC cited a long-standing rule, including Rule of Evidence 901B1, 4, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a fourth nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in, again, because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. So I won't even mention them then. The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has three components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's going to go down for this. We're going to pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you,
All right.
Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it. But there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant, is it material, and what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of defining the value for which this is being emitted. I do have some issue that it's really not under the context of Bowdoin, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Okay. Mr. Yannetti, do you want to respond?
I know we always wait for our, I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit text messages. That's our choice, and we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay, and just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes. No, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Dever, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule 14.
All right, so you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. And we have no obligation to do that. We have no intention.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research on the text messages. Want to be heard, Mr.
I
Brennan?
thought you were standing up, Your Honor. No.
Oh, no, okay. All right, I'll see everybody Monday morning.
Thank you.
Please.